For all I know, she could be making it all up. As certified straight A students, we're very fluent in Boone'isms. We have body cam memorized. We know this case front and back. Yeah? Yeah. So when we saw the closing arguments, we knew something was quite off. Just like when we read that, well, I'll share it with you. I'll save that. Let's take a listen, a rewind, and see if Sarah wrote this or not. Be right back.
The debt is satisfied, or other unpaid child support and alimony as a statutory rate. As of July 1st, 2025, the interest rate for unpaid support is set at 8.90% per year and may vary annually. Interest begins accruing on the overdue balances as soon as a payment is missed, and means the longer arrears go unpaid, the higher the balance grows due to the compounding interest. In many cases, interest can become a significant part of the arrears balance, so it's important to address unpaid support as soon as possible. 8.9% interest times 62 equals $5,518. $5,518 interest plus $62,000 arrears equals total owed by petitioner, former husband, pre-deductions from the court of $67,518. 9. Respondent, me, is requesting $300 to be deposited by the petitioner, former husband, in her DOC inmate account on the first day of every month until the debt is satisfied, or other arrangements have been made at her request pending her appeal. Oh my God, this would be such an injustice. Sarah is trying to set up her life sentence. The rest of her sentence, she will be sitting like a fat rat in her cell, and Brian will be pretty much paying for her crime. Leave a comment below if legally she has any ground. 10. Dollar amounts from her financial affidavit needed for her son, such as communication, gifts for holidays, etc., will be billed accordingly from total amount owed and is separate from monthly payments to her inmate account. Further arrangements can be made, if applicable, upon order of the court after formal judgment has been made concluding trial. Oh my God, Sarah's scaring me, you guys. In conclusion, respondent, me, is not requesting a new award of alimony based on her actual need or circumstances, rather graciously asking the court to enforce the original order, which was/is active during her incarceration without any stipulation of or permission.
Right?
I thought about that.
Okay. Okay, you left them in the back.
Removed and made known to immediately to protect him from to hold petitioner, former husband, accountable for the arrears and interest accrued due to the actively violating compliance according to court orders and Florida law, justifiably upholding the respondent's, me, constitutional rights. And proper inclusion while seeing her good faith efforts in patiently cooperating in every manner possible, even under the added, quote, chaos created by the petitioner through their perpetual unlawful attempts of advantageous gain and control of this case as a whole. Wow, so now she, again, moral authority, but she is the person that created this chaos. She created the whole ordeal. Why Brian had to uproot his entire life and his child immediately to protect him from her and her circus. But even if she doesn't have an attorney, someone is helping her with these documents. I know she is a wordsmith. She likes to pile on the unnecessary words, but it seems like she's getting some help. The petitioner's bad faith also of automatically assuming their success in overruling the court and taking advantage of the disadvantaged respondent, me, by implementing their rules of not paying or cooperating with anyone should not be rewarded, rather removed and made known to all parties. Authority belongs solely to the court, and orders are given for reasons of justice, formally, legally, and constitutionally. So, Sarah should accept her sentence, right? If justice is to be served formally, legally, and constitutionally.
I have one last question. You realize you're the person that killed him, right?
I thought about that.
Okay, you left him in a bag when he's begging you, saying, I can't breathe, let me out, and you said, fuck you. And you got up off the couch and went upstairs and left him in that bag.
Not intentionally.
Again,
I would never do that to George.
you did.
Not
It happened.
intentionally. Know that.
I don't.
Know that.
You got up and you went up to bed.
Alcohol is a shitty thing. It's alcohol. Again, the reason that you killed.
Okay, I'm back. I know that was a bit of a long clip. I just needed you guys to get the full gist of it, not the tip of the tip. Again, we all came down here willingly, so there is no malicious. Nonetheless, who do you guys think wrote that document? It was pretty good, right? Had us a bit frightened for a second. We thought former husband was going to have to break the bank. Pardon me, there's a little human that wants some medical pancakes. Be right back. Say thank you.
Happy mommy. Pancakes.
You're welcome, baby. Okay, I need all of my certified straight A students and excellent mothers to let me know how I did in the chat. It isn't quite perfect. Nonetheless, the little human is happy, overjoyed, and the edges are crispy. Shout out to you guys down in the chat, at home, in your cars, everywhere, tuning in. Replay crew, you know we can't do it without you guys. Make sure you let us know you're here. Okay, back to former husband breaking the bank. That was a pretty vigorous document for someone who thinks Sarah was guilty and never should see her son again, right? I'm like, this guy was in too deep. He was fighting for her rights at the same time, fighting for his life to get some documentary questions answered. Yeah? Let me know below. It's so mysterious. Switching gears, let's head over to the facility so that we can just have a quick reminder of what Sarah is really like behind the walls. On the phone, we hear her complaining about no running water. The girls are doing this and that. Nonetheless, from the behavior notes, it shows that a whole different story, I'll say. Almost as if Sarah was running the joint and she wasn't backing down. Let's rewind to one of the hair braider incidents. Sarah was getting information from everywhere. She was getting a sensory overload. She felt so important. So many people were reaching out to her. On 3/16, while working in the dorm, inmate Boone approached the officer station and stated she was still having issues with inmates Willis, Quashonda, Linton, and Sandra. I spoke with all inmates concerned due to them having a disagreement in the bunk area. Inmate Boone stated that inmate Willis and Linton were harassing her and calling her a KILLER. Again, I spoke with both inmates about the situation. Both inmates stated that inmate Boone was lying. Linton and Willis stated that they were arguing because Boone is talking about them while she thinks they are sleeping. Due to inmate Boone demanding that both inmates be separated and she not be moved, I felt that
there was inmate manipulation in play. I spoke with Corporal Sutton about the incident, and she stated she would speak with all the inmates involved. Isn't that something? Sarah doesn't want anyone calling her names, but she calls people names all day. POS, former husband. Yeah. And that corporal was absolutely right that there was manipulation in play. Sarah's demanding that these inmates be separated and she be the one that stays in the dorm. Oh, Sarah. Jasmine Green, negative officer contact. During a random locker search and shakedown of inmate Boone's bunk area, inmate Boone had the following items in her locker. 1 bottle of lotion that contained an unknown white powdery substance. 1 white roll of medical tape. 2 Sandy hand wipes and several Kleenex tissue papers, and several sheets of notebook paper and paper clips. She also had a Head and Shoulders shampoo bottle with hand sanitizer inside. Inmate Boone was asked what was inside the bottle, labeled lotion, but had white powdery substance inside. She replied that she didn't know, and that she got it from an inmate that was no longer in jail by the name of Ashley. Inmate Boone has violated 3.10, possession of any contraband, anything not authorized for retention or receipt by the inmate and not issued to him or her through regular facility channels. Inmate was also counseled, appeared receptive, and understands that future incidents will result in formal disciplinary action.
She said she didn't know what it.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
I'm sorry, but Sarah's already leading with mistruths. We've seen Lana tell her to take the plea deal and explain how much time she would have. We even saw her brother Philip explain to her when bitch-ass Cashman told him to encourage Sarah to take the deal. He explained the scoreboard to Sarah also, and guarantee her bunkies and those scissor sisters in the Big Bay, they told her as well, like, oh wow, you should take the deal, 15 years. I'm pretty sure she had a lot of conversations about the scoreboard. She was hoping to get that interrogation thrown out because she knew the impact of it. Imagine a trial with no interrogation or no video. Sarah would have manipulated the trial so much. I'm so happy that she didn't take the deal.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge, I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.